and welcome everyone into yet another episode of Law Scope. I'm Sana, your legal expert from Hitbullseye, and in today's video we are going to be discussing 1st to 15th March 2023 current legal news. There are 4 important judgments that we are going to do for this fortnight. So let us get into the video. The first judgment that we shall be discussing is the state of Chhattisgarh versus Amar Kumar Singh. So basically what happened in this judgment was that the Supreme Court stated that it is desirable that the FIRs in corruption cases aren't quashed at the investigation stage only. So in this particular case, the bench comprising of Justices S. Ravindra Bhatt and Dipankar Datta, sorry, they basically stated that it's a common observation that whenever there is a change in the regime, so whenever there is a change in the government, there is an newly elected government, it tries to oust or it tries to indict the members of the previous government by charging false allegations of corruptions, etc., which is a common norm which has been seen from years immemorial, right? However, what you cannot do in this case is, it would be inappropriate for the court, any of the high courts for that matter, to quash that FIR only on the basis that it is on the face of it is seeming that the new government has tried to take any kind of vengeance from an old party member or a person who was in the previous government which is not ruling anymore. So at any time of quashing a corruption case, you cannot quash it only with the reason that it smells of malevolent intention by the new government or it smells of vengeance by the new government. Because here the corruption charge is the charge that has to be investigated. Here an offender cannot be allowed to go scot-free only because of the fact that he has some tiff with the government and he cannot take the benefit of the same. So that is why earlier also in Lalita Kumari versus Union of India, the court had made it very clear that the police can do a preliminary inquiry. Otherwise, if it is a cognizable offence, that the police is required to lodge an FIR. However, in 5 cases, in matrimonial cases, medical negligence cases, cases of inordinate delay, then in cases of commercial disputes, and lastly the cases of corruption, in such cases the investigating agency can do a preliminary inquiry. Going by the same rationale that had been drawn from Lalita Kumari judgment, in this case also they said that we cannot let the corruption cases accused go scot-free, and the cases are such that first of all we have to delve into the concept of whether or not they have done the crime or not. So the material in front of the court at the investigating stage is not enough to quash the FIR. So that is why let the investigating agencies delve into it, let the investigating agencies collect enough of material, and then if they are not able to find any sufficient material enough to form a charge sheet, then they should only be able to go scot-free. So moving on to the next case. This case is Ashwini Kumar Upadhyay versus Union of India. So sorry. It is the bench, as you can see, is Justices K.M. Joseph and B.V. Nagaratna. The bench in this case stated that a country cannot remain prisoner of the past. The Supreme Court dismisses a plea to rename cities named after Muslim rulers, stresses on India's secular color. So basically, Ashwini Kumar Upadhyay is a senior advocate as well as he also belongs to a certain party, etc. And he is basically an advocate and a BJP leader, as you can see. He had filed a petition stating that all the names, all the roads, all the cities, anything that has been named after the Muslim rulers who invaded India, the names should be changed. So essentially the names, if we see, they become a part of the culture, and minority, whether it be the linguistic minority or the religious minority, they have a right to safeguard their culture as well under Article 29 and 30 of the Constitution of India. Here also the Supreme Court, going by the same rationale and going by the same principles enshrined in the Constitution of India, stated that a country cannot remain a prisoner of the past. A country cannot remain a prisoner of the past, and because of whatever happened in the past, whether somebody invaded somebody, etc., or whatever happened in the past, you cannot jeopardize the future of the current generation and even the past of us. So basically, by divide and rule policy, if we see, divide and rule policy was a policy that the Britishers adopted. It cannot be allowed to be adopted in this day and age, and we have to be very careful about this. Adding on to this, the bench also stated that that Hinduism, when it comes to metaphysics, it's the greatest religion that the world has ever seen, and that is why the advocate, the petitioner, should not go into these petty issues and should not try to target one particular community, so as to create a divide and rule kind of a situation. So here the Supreme Court, let us have a look at what the Supreme Court had stated. The Supreme Court stated that the golden principle of fraternity meaning brotherhood, which is enshrined in the preamble, is of the greatest importance and rightfully finds its place in the preamble as a constant reminder of all the stakeholders that in maintenance of harmony among different sections alone will lead to a true notion of nationhood, bonding sections together for the greater good of the nation and finding fraternity. So the court has again and again in this particular case stressed upon fraternity, brotherhood, the feeling of community in the nation, etc. We are therefore of the view that the reliefs which have been sought for should not be granted by the court, acting as a guardian of fundamental rights under Article 32. And therefore, the Supreme Court mentioned that while the principles enshrined in Article 14, that is the right to equality, belongs to all the citizens of the country, and that is why the court refused to deal with the petition. Now moving on to the next case, this is Siddharuda alias Karna versus the state of Karnataka. In this particular case, the Supreme Court ruled that sexual intercourse with wife is essentially, the Supreme Court acquitted the husband of rape relying on exception 2 to section 375 IPC. The bench in this case is Justices B.R. Gavai and Justice Sanjay Karol. In this case, basically what happened was that the husband was accused of having sexual intercourse with a minor wife who was under 16 years of age, basically. So now, what had happened is, the law, if we see regarding this, is having sexual intercourse with a minor person is an offence. It is punishable under the POCSO Act, that is the Protection of Children from Sexual Offences 2012. And also, if we go under IPC as well, rape is considered to be a crime, and rape is considered to be rape when it is firstly against the will, then without the consent, then with the consent, but when the person is not capable of giving any consent by the reason of, say, she was under a misconception, or she was not in a state to give that consent, or she was in an inebriated manner, she was in an inebriated stage, or some other reason. It can be any other reason, by fraud or force, etc. And also, one of the reasons that have been listed herein are that if the girl was incapable of giving any kind of consent by the reason that she was under 18 years of age, so even that constitutes as rape. However, there is one exception to this, that is exception 2 of section 375, which categorically states that if the minor is the wife of that particular person who is considered to be the accused in this present case, then the husband is exempted from it, provided if the wife is from 15 to 18 years of age. Meaning to say simply that if the husband is having a sexual intercourse with a wife who's under 15 years of age, it is still rape, even if the relation between them is that of husband and wife. But if she's from 15 to 18 years of age and she is the wife of that accused, then it won't matter, then she can be taken out of it, and it won't basically constitute as rape. So now basically what had happened was in 2017 there was a very important judgment called the Independent Thought versus Union of India. So in this particular judgment, Independent Thought versus Union of India, the court found out that it was the 15-year age limit that was mentioned in the IPC was unconstitutional, because at all the other places the women under 18 were not allowed to give consent. So it was arbitrary, it was frivolous, it was not making any sense, and that is why the Supreme Court in Independent Thought struck this portion down. Meaning to say, from 2017 the rule has been that every husband under 18 years, if he has sexual intercourse with his wife only who's under 18 years of age, then he also would be said to have committed rape only. However, now considering this case, the Supreme Court stated that the Independent Thought case would follow the prospective overruling effect. Meaning to say that any offence that has been done after 2017 will be, the accused can take benefit, or the accused can take advantage of this particular case. However, in this case, the Siddharuda alias Karna versus the state of Karnataka, this incident had happened before 2017, and that is why this strict rule of IPC as it was before amendment by the case of Independent Thought versus Union of India would apply, and any girl who was from 15 to 18 years of age before 2017, any rape on her by the husband accused would be exempted from the same. The next case in this regard is, so the next and the last case that we are going to cover is section 313 on CRPC, that a written statement of the accused has to be considered in the light of the prosecution evidence, said the Supreme Court. Premchand versus the state of Maharashtra, and the bench constituted of Justices Ravindra Bhatt and Justices Dipankar Datta, as you can see here. So essentially when we talk about section 313 of the Code of Criminal Procedure, it is essentially what happens in a criminal procedure is, at the criminal procedure commencement of the trial starts from the framing of charges under 227, 228. 227 if it is a sessions court trial, that is, and if there is no adequate framing to be done, if the material is not sufficient in front of the judge, then he can discharge the person under section 228. After this, the first thing that comes is that the prosecution is going to explain its case and start taking the evidence of the prosecution. Once the evidence of the prosecution is done, then before calling the witnesses for the defense, the court should, under section 313 of the CRPC, the court is bound to call the accused and ask him questions on the case generally. So first of all, this is because of the fact that the accused should have a right to be heard. The accused should have a right to explain the circumstances in which whatever crime it was that happened. And secondly, the court and the legislature is also aware of the fact that they cannot bring the witness, or they cannot bring the accused under oath. Why? Because that would be breaching Article 20, Clause 3 of the Constitution of India, which is the right against self-incrimination. So a person cannot be compelled to come to the court as a witness, but however, a person's aid in understanding his perspective of the crime is also required for the judge to make up his mind as to whether or not he has done the offense or not, or what he has to say in the explanation of the allegations, whatever the prosecution is putting against him. So all this exercise is not done on oath. Now talking about the facts of this particular case, that is the facts of Premchand versus the state of Maharashtra. In this case, what had happened was the FIR was registered by the mother of the deceased. The mother of the deceased approached the police station stating that the accused had killed the victim, and here the trial court convicted the accused, the high court convicted the accused, or it upheld the conviction of the accused. However, here the Supreme Court noted that the accused himself was never brought to the court, and he was never asked about what were the circumstances in which he was in which the crime took place. So when the Supreme Court finally called him and asked him as to whether or not he had a reason as to kill him or not, the accused explained that he used to collect rent from the victim after every 2 to 3 months. And when he approached, the victim started threatening him. So essentially, the act done by the victim was the act done by the accused, was a matter of self-defense. So now here the Supreme Court started understanding what were the facts and circumstances which were missed in the courts below. And that is why it laid down, just to be safe, it laid down certain guidelines that are to be followed by the lower courts at the time when they are calling an accused. Why? Because the accused also has a right to be heard. So now when you call an accused not as a witness but only as only in the capacity of an accused, not under oath, but only generally to take his opinion, to take aid from him, to understand his mindset, to understand his demeanor, etc., that is the time when you need to follow these guidelines that we are going to discuss one by one. So first thing, 313 is something that is valuable safeguard for trial process to establish the innocence of the accused. So it becomes very important. This is a very important instrument. This is a very important tool for the accused to prove in a manner, even by not becoming a witness, he can prove that he is not guilty. Section 313, which is not intended to ensure a direct dialogue between the court and the accused, casts a mandatory duty on the court to question the accused generally on the case from the purpose of enabling him to explain personally in any circumstances appearing in the view of the evidence against him. So basically he is allowed to give a general view of whatever he had to say about whatever has been produced by the prosecution in order to indict him or in order to lead him to conviction. Then when questioned, the accused may not admit his involvement at all and choose to flatly deny and outrightly repudiate whatever is put to him by the court. And the accused may even admit or his own incriminating substance adduced against him to adopt any illegally recognized defenses. In the two rules, basically what the Supreme Court meant to say was that once he's brought to the court, once the court is asking him generally the questions, he can flatly say that I was not involved in the crime, I do not know anything about the crime, I wasn't there, I wasn't involved, period. And also he can also take this defense that yes, this thing happened in front of my eyes, I was involved but only in a certain manner, I was involved but I was doing my duty only because I was say intoxicated against my will or without my knowledge, or I only did it because I was undergoing a period of insanity, or I only did it in a period of self-defense against my property or my life or somebody else's property or somebody else's life. So he can take whatever legally recognizable defense that he chooses to. An accused can make a statement without the fear of being cross-examined, very important, by the prosecution or the latter having any right of cross-examination. The explanation that an accused may furnish cannot be considered in isolation, but it has to be considered in conjunction with the evidence adduced by the prosecution, and therefore no conviction can be premised solely on the basis of section 313 of the 313 statements. So basically in these two rules, first of all, the Supreme Court tried to explain that under section 313 of the CRPC, it is a very important point to be noted here is that the accused is not under oath. So he is not under a duty to say the truth. He should be saying the truth, but he is not under a duty. He won't be penalized. There are certain offences written down throughout the IPC in which if a person lies in front of the court, he is said to have furnished false evidence, and that is why if he does so in front of a court or any kind of this kind of an authority, he can be jailed for up to 7 years of imprisonment. However, this rule does not apply here, and he can he will not have any penalty if he is even discovered to have lied. Secondly, at this point of time, even if any incriminating statement comes out of the mouth of the accused, and even then there is not sufficient evidence presented by the prosecution that is going to lead to his conviction, then the court is going to give him that benefit. The court cannot rely on only his statement, because first of all, this statement has not been cross-examined, and second of all, this statement is a very weak piece of evidence. Then and then it has to be, so basically it has to be read in conjunction with all the other evidence. Statements of the accused in the course of examination under section 313, since not on oath, do not constitute evidence under section 3 of the Evidence Act, and yet the answer given is relevant in finding the truth in examining the matter and the veracity of the prosecution case. So it can be used to check the case of the prosecution basically. The statements of the accused cannot be dissected to rely on the inculpatory part and ignore the exculpatory part, and has or had to be read in the whole inter alia to test the authenticity of the exculpatory nature of admission. Meaning to say that there are two parts in a statement, or whenever an accused is making a statement, it can be divided into two parts. One is the inculpatory part, that is going to cause trouble to him. So basically where he is saying that yes, I was present at the scene of crime. This is an inculpatory part. But I did not even touch the victim. That is an exculpatory part, right? So in this, you cannot dissect, you cannot divide the statement according to your own convenience. You cannot divide the statement so as to only admit those parts which are going against the accused, and to reject all those parts which are not going against the accused. This was also stated in the state Palwinder Kaur versus the state of Punjab. If the accused takes the defense of any alternative versions of events or interpretation, the court has to fully analyze and consider the statements, much so like in the present case where he gave a very whole different scenario of the battle that happened or the dispute that had happened. So he never denied that the dispute happened, but he expressed that dispute in a very different light from his own perspective. Any failure to consider the accused's explanation from incriminating circumstances in a given case may vitiate the trial or endanger the conviction. So if this right is basically taken away from the accused person, it can even lead to setting aside of the conviction of the accused. Exactly what happened in the present case of Premchand versus the state of Maharashtra. So this is all for today's video. I hope you like the video, and if you have any doubts or if you want to know more about any particular topic, please write in the comment box below, and please do like the video, share and subscribe. Thank you so much. See you next time.